Hello, my name's Osha. I like talking about American presidents, and today I'm going to be continuing my discussion on the Fourth Amendment. So, the Fourth Amendment, of course, it's one of those amendments in the Bill of Rights that deals with the rights of the accused, and of course, they're the Fourth, the Fifth, the Sixth, and the Sixth, Seventh, and Eighth Amendments. Now, let me just quickly state them. Fourth Amendment, of course, deals with prohibits illegal search and seizure, right? Uh, and the Fifth Amendment, uh, protects your right not to incriminate and also due process of law. The Sixth Amendment deals with your right to fair and speedy trial with a trial by jury, right to a counsel, right to a public trial. Okay. And the Seventh Amendment is civil, it's not criminal, right? The Seventh Amendment says that, you have a right to a jury in certain federal civil suits, right? In certain federal civil suits. So whatever what I'm discussing today does not apply to the Seventh Amendment because it's civil. Today, the Fourth Amendment deals with it's in the territory of criminal law. The Eighth Amendment, of course, is it prohibits excessive bills and fines and cruel and unusual punishment. Right, that's after the defendant's been gone to trial and they've been convicted, or they're awaiting trial in terms of bail. So today I'm going to be discussing the Fourth Amendment, and this rule also applies to the due process of law. So I'm going to be talking about what's an extension of the exclusionary rule. So I'm talking about the fruit of the poisonous tree. So the fruit of the poisonous tree is an extension of the exclusionary rule, and the exclusionary rule, um, it's it's called, it's an example of what's called a prophylactic rule. A prophylactic rule is what's a judicially crafted rule uh, intended to protect a constitutional right of the defendant. And if that right is violated, it provides consequences, right? To make sure the constitutional right is not violated. So in this case, in the Fourth Amendment, you know the the defendant has is protected against illegal search and seizure, right? And probable cause is required. A warrant is required. Um, Now, note in criminal cases, it's the state, it's a government that's bringing a charge against the defendant, right? It's a government, not a party that you don't like, So, for instance, if the defendant is charged because he got into a fight with his neighbor, right? And the police show up, he's arrested or whatever. So the criminal charges for assault is not it's not brought by the neighbor, right, that was involved or that was a victim. It's not the neighbor that's prosecuting that criminal case. It's going to be the state versus the defendant. So it's a state that prosecutes crimes, criminal cases, because it's considered an offense against the state, right? So the defendant, uh, who's alleged to have been a victim of the defendant, an assault brought on by the defendant, is merely a witness, right? They're just merely a witness on behalf of the state, because the state is going to provide evidence, right? To be able to prosecute, they're going to have to provide evidence in court before a jury beyond a reasonable doubt that the defendant is guilty, that they did commit a crime. So it's an offense against the state. It's the state bringing charges, prosecuting a case against the defendant. And in the process, of course, they need evidence to be able to prove their case in court before a judge, before a fact finder. It could be a jury. And so there's due process and fairness in our legal system, right? So there's certain rules and safeguards that are provided so that the state, the government, the police, they can't gather evidence through illegal means. And this is what Fruit of the Poisonous Tree is talking about, right? So if there's illegally obtained evidence, right? If evidence is obtained through an illegal search, for instance, an illegal search, that's a warrantless search. For instance, if the police enters the defendant's house without a warrant and they find drugs, so the poisonous tree, right? The poisonous tree is the illegal search, right? And so if they find something, if they find uh, contraband, if they find drugs, then that's the fruit, right? And so under the law, right, uh, because it was an illegal search in the first place, violating the rights of the accused, of the defendant, that will be dismissed, right? That evidence is inadmissible, right? That evidence will be suppressed. So the attorney of the defendant would file a motion in court asking to suppress that evidence. So that evidence cannot be used to prove the defendant's guilt in court, in a court of law. So that's what the fruit of the poisonous tree is about. And so again, it's a legal technicality. It's one of exclusionary rules. Is they also they're called legal technicalities because the defendant is using a defense that has nothing to do with the commission of the crime, with whether they're guilty of committing the crime that brought them to court or not, right? The way the defendant obtained evidence, has nothing to do with whether the defendant actually committed the crime or not, right? So that's why it's normally called illegal technicality, and it's a prophylactic rule. A prophylactic rule, it's a legally crafted uh, rule that safeguards the constitutional rights of the defendant, and it provides consequences when those rules have been violated by the state, by the police, and it's supposed to act as a deterrent, right? It's supposed to deter the state or police from breaking the rules, right? Well, let me go into the backstory, the history of Fruit of the Poisonous Tree, and so I'm going to go into the backstory of Fruit of the Poisonous Tree right now. So the origin of Fruit of the Poisonous Tree is from uh, it starts with uh, uh, the exclusionary rule. The exclusionary rule is from 1914, a case Weeks versus the United States. That's where its origin is from. But that established that evidence gathered by the government, by the state, by federal agents, uh, through an illegal search and seizure, um, is prohibited, right? It can't be. It's inadmissible. It can't be used. So that's Weeks versus United States. I'm going to do another video just to explain that case. Now, after that, the law started to evolve. Again, this is still within the Fourth Amendment rights. It started to evolve into we had the a 1920 case. It's Silverthorne Lumber Company versus United States. So Silverthorne Lumber Company versus United States says that evidence that's derived from a warrantless search, an illegal search, right? Something that violates the Fourth Amendment, right? For instance, a warrantless uh, from an illegal search and seizure, evidence derived from that. So derived, right? It's derivative, cannot be used either, right? And I will quickly talk about that Silverthorne um, Lumber Company case. That would be helpful. Um, so, and it's also interesting. I'm just going to give the comment of Justice Oliver Wendell Holmes Jr. Right, he's a luminary in American jurisprudence. He was a giant on the U.S. Supreme Court, so you will hear that name a lot. It's often quoted in law school. When you go to law school, you get that a lot. So Oliver Wendell Holmes said in that decision of Silverthorne Lumber Company versus United States of 1920, which established the uh, the underlying rule doctrine of uh, which eventually was coined as a metaphor later on as fruit of the poisonous tree. Right. So Oliver Wendell Holmes said that it is a lesser evil that some criminals escape than for the than that the government play uh, play an ignoble part, right? So he's talking about that the government shouldn't be ignoble. By the way, means disgraceful, right? Something disgraceful. So, for instance, the government should not be planting evidence. The government should not be committing a crime because violating the rights of the defendant or a citizen or anyone in order to gather evidence against them, in order to incriminate them so they can lock them in jail. So that's disgraceful. That's not fair. It violates, the integrity of our legal system. So that was why Oliver Wendell Holmes used that word ignoble, that it's disgraceful. And he said it's a lesser evil for some criminals to escape than that the government play an ignoble part, right? In that is uh, uh, in getting through illegal means incriminating evidence that violates the rights of the accused, the defendant. So Silverthorne Silverthorne Lumber Company versus United States of 1920. What what happened was the Silverthorne, there was an attempt at tax evasion, and so the government, entered the offices of Silverthorne without a warrant and seized uh, the company's books, right, their records, seized the records, the tax records, right, the tax documents, seized them, and then made copies of those tax documents, right? So those copies, so even though the original were returned, the copies also were not could not be used as evidence because there was no warrant, there was no search warrant, there was no warrant to get those documents to enter the premises. So it was illegally obtained. So the fruit, the derivative, at that time it wasn't called the fruit, it was called the evidence derived from the illegal search. That was also deemed inadmissible, right? And then in the 1939 case, Nardone versus the United States, this dealt with wiretaps, right? This dealt with wiretaps, Nardone versus United States, and that was when Justice Frankfurter actually coined the phrase "fruit of the poisonous tree." So the fruit is the derivative, right? Like the example I just gave in the Silverthorne case. So the copy, so that's the fruit, and then the poisonous tree itself is the illegal search, the warrantless search. That's the poisonous tree. So any fruit of that poisonous tree, of an illegal search or seizure, then and there was a seizure, of course, because they seized the copies of those the tax documents. Those were seized. So that was a poisonous tree, an illegal search and seizure, and then the fruit was a copy. Now, in Nardone versus United States in 1939, what happened was um, there was an illegal wiretap, and that wiretap, in fact, violated a Communications Act of 1934. The Communications Act of 1934 prohibits unauthorized interceptions and divulgence of information, communications of interstate communication. So it prohibits the interception or interference of um, uh, interstate communications, and it prohibits its divulgence as well. So the government, federal agents they'd used wiretaps, right, and that was actually a violation of a federal law. So it was a federal offense to intercept interstate communications, because then the beginning of the phone lines, they were under the uh, Interstate Commerce Act. I was that what it was called, Interstate Commerce Clause, or I think that's what ICC is. So it was under that, and so there was a federal. It was a federal offense to intercept, uh, those communications, right? Unauthorized interception or divulgence of those interstate communications, messages, information was a federal offense. So that was when Justice Frankfurter, he coined that term in the case Nardone versus United States, saying that, well, the fruits, and in this case, the conversations that were intercepted through those, that were the conversation that was obtained, and the knowledge that was obtained through the conversation of a crime, or, that was a fruit a uh, of the poisonous tree. The poisonous tree was the crime itself, the illegal interception, the search, illegal search, right, the illegal surveillance of those telephone conversations, the wiretaps, because there was no warrant, right? They needed a warrant from a court, from a judge. So that's how the term fruit of the poisonous tree came about. Now, of course, there are exceptions to the rule, right? The exceptions to the rule. Um, some of those general exceptions are, for instance, if there's what's called attenuation between the causation, right? Attenuation between the connection uh, between the illegal act, right, and the actual evidence, right. For instance, that attenuation could have come about from passage of time, or intervening events. So that's a complicated explanation, though. But that's basically what it is. For instance, if it's far removed, the evidence is very far removed from the illegal act, the illegal search and seizure, then a judge may decide to use it, that it allow the prosecution to use it in court. Or if the evidence would have been obtained inevitably, right? If it was inevitable that that evidence didn't have to go through, would have, the government would have gotten that evidence inevitably, eventually, without having to have gone through the illegal means, the illegal search and seizure that they used, then, you know, that can be used, because it sort of removes the taint. That's what they say. It purges the taint. It removes the taint of illegality. And also, if the evidence was obtained independently through an independent source that's lawful, right? That's not tainted. So these are exceptions to that uh, fruit of the poisonous tree, the exclusion. Because the notion of the fruit of the poisonous tree is that there's an illegal search and seizure that violates the right of the defendant, and therefore the government cannot use that evidence against the defendant in a court of law. So it has to be suppressed, it has to be removed. They can't use it to convict the defendant, right? Because in a court of law, when the government has charged a defendant with crimes and they're prosecuting, it's the burden of proof is theirs, and what they're going to use to convince the jury, the fact finder, or the judge to get them convicted, to find the defendant guilty, is evidence. So if they can't use evidence that because they obtained it illegally, right, because it's a prophylactic, if they obtained it illegally, then then they can't win their case, right? There can be a mistrial, or the case can be dismissed, right? Or they would not be found guilty because they weren't able to use evidence, because they used it, they obtained it illegally, right? So let me give examples. An example, for instance, imagine if a cop who suspects somebody's a drug dealer, right? He's been following this guy, casing his house, and he sees that, okay, this guy he knows he has a family in the house, and he has just a child. He has a young child in the house, as a teenager, and he sees the owner of the owner of the house, who he suspects of being a drug dealer, has left, right? And the police officer, instead of going to get a warrant, right, a search warrant from a judge, he decides to go in and be a smart guy, wise guy, smart ass, smart aleck, or whatever, goes to the house, knocks on the door. The man's son, teenage son, opens the door, and then he uses his uniform to intimidate the boy, to let him in. That, okay, the dad is in trouble. He doesn't have a search warrant. The kid doesn't know anything. The kid lets him in, and then the cop starts to snoop around. He finds a drawer, and then he finds a baggie. I use that word baggie because our professors in law school like to, those are the terms they used in criminal law. Baggie. I still wonder what's a baggie. So baggie, it's got drugs, right? Baggie of drugs. It could be cocaine. So he's got, let's say it's cocaine. He's got drugs. He finds a baggie in the drawer, and so so that baggie he found, and then that's, first of all, he can't use that because he didn't have a search warrant, right? He can't use it in court. That's a fruit of a poisonous tree. The poisonous tree is the illegal act, the illegal search. He came into the premises of the defendant without a search warrant. It was unauthorized, right? So he violated the constitutional rights, the Fourth Amendment of the of the of the defendant, right? Let me recite the Fourth Amendment again, so we just remember. And I have it from memory. Hopefully, it's down pat by now. So, the right of the people to be secure in their persons, houses, papers, and effects against illegal searches and seizures, right? So that's an illegal search, shall not be violated, right? Shall not be violated. That's uh, that's a violation right there, right? So let me just say the whole thing. But I just wanted to point out, the element of the Fourth Amendment that's a poisonous tree, right? So he's gone in, right? He's done an illegal search, and he's violated the constitutional right of the defendant by going onto his premises. He's going to his house, right? Oh, let me give the whole thing. So the right of the people to be secure in their persons, houses, papers, and effects against illegal searches and seizures shall not be violated, and shall issue no warrants shall issue but upon probable cause, right? But upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So the cop didn't even get to any of that. He didn't bring an arrest warrant. He didn't go to a judge or a search warrant. He didn't go to a judge to obtain a search warrant. He didn't do any of that. He just went without a search warrant. So the illegal entry, the illegal, searching, going to knock, and using his uniform to intimidate the kid, that's the poisonous tree. That's the illegal act. So the poisonous tree is the illegal act, the illegal search and seizure, and then the fruit is what he obtained through the illegal the illegal search, the unauthorized search. So he found that baggie, the cocaine. That's illegal. It's going to be suppressed. He can't use it. It's going to be thrown out, right? What else? So assuming that he now, because he just sees the cocaine there, he does the fact that it's there doesn't mean that the owner is responsible. He doesn't know. It could be the wife. It could even be the kid. Who owns it. It could be the underage kid. Who owns it? The teenager. Who owns it? So he starts now question um the teenager, starts to pressure him and ask him, hey, whose baggie is this? Whose baggie is this? Who does this belong to? And the boy, confesses and says it's his dad's, right? He can't use that oral testimony as well. That's a fruit of a poisonous tree. So he can't use any of that. Basically, that's what the fruit of a poisonous tree is about. Um, so so the exclusionary rule, again, it's extensive, so Fourth Amendment, Fifth Amendment, Sixth Amendment, those again deal with protecting, the rights of the accused in court. And the exclusionary rule does not only apply to the Fourth Amendment, and they have to do with due process, right? So Fifth Amendment itself, like I said, is due process. So the exclusionary rule can apply to Miranda rights. Imagine if a kid is arrested for a crime, he's arrested and taken to the station, and he's saying, well, he's not going to talk, he wants his lawyer, right? And they don't really read him his Miranda rights. So under the law, if someone's arrested, they have to read them their Miranda rights, right? It's from a 1966 case, Miranda versus Arizona, that established it. We see this in movies a lot. Your Miranda warning is you have a right to be, to remain silent. You have a right to have an attorney. If you can't afford one, the state will provide you one. And, anything you say or do may be used against you in a court of law. So they don't read him his Miranda rights. He immediately asks for his attorney. They ignore him. They take him to the station. They're pressuring him because he's a kid. He's intimidated by the environment. They compel him. They coerce him. And then he starts talking, right? He starts confessing to things. He starts saying things. There's the exclusionary rule applies to that. So those are violations of his constitutional rights. Now, the other elements, within the Fourth Amendment, probable cause. I'm going to do other videos. I want to do subsequent videos so to keep this short. This is already going on 30 minutes, and so I'll break it down and do another video on probable cause. Do another video on the exclusionary rule in general, because the fruit of the poisonous tree is part, is a strand of an element of the exclusionary rule. I'll stop it here. My name is Olurotimi Osha. I like talking about American presidents, and today I was just discussing the fruit of the poisonous tree, which is part of the Fourth Amendment. I will keep you posted. Thank you.